Hello, thank you for joining Gray Duffy's ride-sharing app webinar. My name is Tim Thornton, and with me is Matt Shorr. We are here today to talk about ride-sharing apps. This is part of a larger sharing economy. There are lots of apps trying to do everything for everybody. There's Airbnb and VRBO to share your home as a rental. There's TaskRabbit, Fiverr to have people run tasks for you. There's Instacart to have people go do grocery shopping for you. And last week in the LA Times, there was an article about services where you can rent your car for an hour or a day or drop it off at the airport while you're on vacation. And someone who's on vacation in your city will use your car. So all of these sharing economy apps create interesting issues about liability and about insurance coverage, which we're here to talk about today. We're going to start with talking about liability. And we're going to focus, of course, on ride-sharing apps like Uber, Lyft, Sidecar, and others. And we'll start with talking about liability, and Matt Shorr is going to talk about that.
Hello, everybody. I'm happy to be speaking to you about this interesting subject today. We're at the cutting edge, needless to say. And a little background information, as you may know, Lyft, which is a competitor to Uber, started out a mere 3 years ago as Zimride, and Zimride, incidentally, is now owned by Enterprise Holdings, which owns Enterprise Rent-A-Car National and Alamo Rent-A-Car. And it was originally developed to allow users to carpool in the San Francisco Bay Area. After Uber successfully developed and deployed its black car service, Zimride developed the Lyft service. And then in response to Uber, competed and developed its UberX service to compete with Lyft. And then we have where we are today, which is essentially 2 to 3, including Sidecar, ride-sharing hailing apps in which they match up drivers with potential passengers. And the reason we thought it would be interesting to conduct this seminar is because there's been a significant change, at least in California, effective July 1 of this year with respect to insurance issues and the types of coverages that have to be maintained and purchased by Uber, Lyft, Sidecar, and the drivers themselves. And Tim will talk about that in a few moments. So from my standpoint, we're going to talk a little bit about liability and what are some of the theories of liability that potentially exist now or might exist in the future, depending how this materializes and morphs. The theories of liability would be, of course, direct against Uber, Sidecar, and Lyft. And those would consist of a failure to train, a failure to supervise, indirect liability through respondeat superior would arise on the basis if Uber, Lyft, and Sidecar determined to have an employer-employee relationship with the drivers. Now, as you know, the employer-employee relationship between the platforms and the drivers is a hotly contested issue right now. There are 2 cases that are pending up in the San Francisco Bay Area before the U.S. District Court. They consist of Douglas O'Connor versus Uber Technologies. For your information, that case number is C-133826. And the other case is Patrick Cotter versus Lyft, Inc. That case number is 13CV04065BC. Essentially, both these cases are dealing with an almost identical issue at the moment. And what's interesting is we've had two separate district court judges being faced with motions for summary judgment. In one case, we had the drivers seeking a determination that they were employees because obviously they want to recover employee benefits and expenses and other protections that are available to them under the labor code. On the other hand, Lyft and Uber have contended that the drivers are independent contractors and therefore they are not responsible to their immediate drivers for the typical employee benefits that would be paid under the labor code. And more importantly, they don't understandably want to be responsible ultimately for any issues that might arise during accidents or as a result of mishaps that might occur during rides. So let's talk about the employer-employee status, and clearly that's going to be one of the signature issues in this burgeoning environment that's taking place right now. And incidentally, there is a labor commission case that's been decided in California. We'll talk about that in a few minutes. But just as a side note, the labor commissioner in California has determined that a given driver who was driving at one time for about 2 months for Uber was in fact an employee rather than an independent contractor, and we'll talk about the effects of that. So what determines whether or not a person who is a driver for Uber, Lyft, or Sidecar is an employee or an independent contractor? And the issue is really a multifaceted factual test. The first issue that you look at is whether or not Uber and Lyft and Sidecar retain the right to control the driver's activities and their work. A number of the factors that courts look at say that the right to control is the main issue, and then there are sub-factors factually that you look at if it doesn't pass that initial test. Then the other theories of relief would be wrongful death, negligence by virtue of a motor vehicle negligence. That is the issue that is currently displayed on your screen under the case of Liu versus Uber Technologies, Inc. That's a wrongful death case in which a driver who was on the app but had not picked up a passenger yet was in the process of picking up the passenger when he had a mishap while driving the car. Unfortunately, the mother was killed, and the two children are suing for wrongful death. And in that case, what's interesting is we've seen some of the cases, or I should say causes of action, that may arise in these types of cases. It sort of gives you a preview of what plaintiff counsel may be seeking to assert in these types of cases. And one of them was negligence of a motor vehicle. It was essentially couched based upon case law and statutory law in California that's developed around distracted driving. The theory being that the Uber app is like a GPS system that requires the driver to interact with the app while he's driving, and therefore is creating a situation where in interacting with the app, he's forced to drive distracted in a distracted manner. Remember, at this point in time, the app sits on an iPhone or an Android phone or some other type of manufacturer's phone, and typically is put in a cradle at eye level so the driver can interact with the app and see the status while he's in driver mode. And there are, to my knowledge, no means at this point for the drivers to interact with the app in driver mode using verbal commands. So it does potentially force him to tap on the app, and if he's not standing still, he's driving, and that's the issue there. The next issue or theory of liability would be negligence per se. That is based on driving statutes passed in California that prohibit texting while driving. Another theory of belief is against Uber and Lyft is product liability, which arises from the implementation of a platform and an application which, as I mentioned to you, potentially causes distracted driving. At least that's the allegation the plaintiff in lieu is making. Another issue that's potentially out there that I have not seen yet, but I think that it's a potential issue, is since the California Public Utilities Commission implemented regulations recently in California relative to TNCs, we now have the PUC code, section 5432 subsection B, and in that provision it requires Lyft, Uber, and Sidecar, and any other platform that's like it, to inform the drivers that their personal automobile liability insurance will not provide coverage in the event of an accident. So there potentially could be liability there where the driver has not been properly informed and given written notification of the extent of coverage or lack of coverage before an accident occurs. Another issue would be property damage. Currently, my understanding is there's effectively a gap, and Tim will talk about that. There's a gap in the coverage under the statute and by virtue of the statute, meaning the statute, as Tim will talk about, takes over for the driver's personal liability policy because of exclusions. But the policy that's been required by the PUC does not address property damage. So what happens to the driver's vehicle if he is involved in an accident? And let's say, hypothetically, it's due to no fault of his own. Let's say, for example, he's driving to pick up a rider, or he's even in the process of performing a ride, and somebody out of nowhere T-bones his car, and now the liability policy would potentially be triggered under the new policy that Tim will talk about. But what happens to the driver's coverage for his own automobile? It's an interesting question, which doesn't seem to be addressed by the PUC regulations at the moment. All right, so let's go back to independent contractor and employee. What are the other facts that you typically would look at other than the right to control? Remember, right to control doesn't necessarily have to be exercised. The main issue is the purported employer, does the employer have the right to control the manner and means of accomplishing the desired result? And that's the key issue in this case. And I will just venture to go out on a limb a little bit that I think that Uber, Lyft, and Sidecar ultimately, at least based on their current practices, either posted in frequently asked questions or in materials that are handed out to drivers, more than likely will probably be determined to be employers of the drivers. And I'll talk about that in a moment. The secondary factors that the courts look at are, is the person engaged in a distinct occupation or business? Is the skill required for the particular occupation specific, or is it just more of a generalized occupation? Whether the principal or the worker supplies tools or equipment in the place where the work is performed. Is the work part of the principal's regular business? In the case of Uber, Lyft, and Sidecar, arguably, the work is being performed For the company that has the platform, without the drivers, the platform is merely a piece of technology. The length of time for which services are performed. In other words, is it going to be sort of a one-off, a temporary, extended, or an extended period of time? The longer amount of time that the worker or driver is working for one of the platforms, more likely that they're going to be determined to be employees. Is the worker paid by the hour or by the job? Now, that really doesn't apply in this particular situation per se. It's sort of a hybrid because the drivers tend to be paid on a weekly basis based upon their net earnings after reduction of administrative fees and so forth by the platform. Did the parties believe that they were creating an employer-employee relationship? Well, there you're really dealing with potentially documents that are given to the driver when he signs up, and potentially Uber, Lyft, and Sidecar would have the driver sign acknowledgement saying that they're independent contractors, not employees, etc. The issue there, though, is that issues like this, as a matter of contract, are not binding on the worker or on the courts. It's merely a factor that the courts will take into consideration. And in fact, the well-known case in California called Kowalski, K-O-W-A-L-S-K-I versus Shell Oil, holds that such agreements are not binding on the worker, and the court will look at the contemporaneous facts to determine whether or not the worker has been misclassified as an independent contractor or whether in fact he was an employee. The same will happen in a third-party injury case in which they're seeking to sue the driver and or Uber and Sidecar and Lyft. And even if the driver is held to be an independent contractor, it would seem to me that Uber, Lyft, and Sidecar potentially can be held liable under a theory of agency since they are running the platform and the drivers are carrying out the task for the platform. Two issues factually that help to drive this issue of whether or not the drivers are employees or independent contractors. And that is, typically, Uber and Lyft have a right to terminate the driver at will, without cause, and for any reason. That is presumed to be strong evidence of an employment relationship. And under the workers' compensation law in California, if a person is performing work or service for a company, the person performing the service is presumed to be an employee, and the burden then shifts to the other party in that relationship to establish that there was no employer-employee relationship. So in that sense, in my view, the deck is a little bit stacked against Uber and Lyft in terms of independent contractor status. One of the other reasons why I think that ultimately what will happen is determining that they are in an employer-employee relationship is at least based on the current setup of rules and procedures and policies that exist between the drivers and the companies that run the platform. The companies, such as Uber, Lyft, and Sidecar, they exercise a substantial amount of power over the driver's activities. Now, you might say, well, how could that be? The drivers can work whenever they want to. They can work as little as they want. It's their car. Presumably, they have their own personal liability insurance for their automobile. How could they be? How could the platform be exercising so much control? And the reason is the drivers can be terminated, as I said. If the customers, the people who ride in the cars, fail to rate the drivers adequately or within certain satisfaction levels that Uber and Lyft specifies, these drivers can be terminated. If the drivers are not meeting certain standards or certain policy issues that Uber and Lyft have specified, they can be terminated. The access to the platform is governed and regulated by Uber and Lyft. Unless they agree to allow you in, you cannot participate in any other way. They control whether the drivers are allowed to work for the platform, and they monitor the driver's acceptance rates and cancellation rates. For instance, if the driver is canceling rides for whatever reason at an unacceptable level, Uber and Lyft reserves the right to terminate that particular driver from the platform. What are some of the recent developments in this? And I think that indicates where we're going a little bit. As you may know, there was a recent California Labor Commissioner ruling in the Barbara Berwick case, which is up in the San Francisco Bay Area. And that is a case in which Ms. Berwick was seeking to be determined to be an employee because she wanted to be reimbursed for about $4,000 in out-of-pocket expenses. In that decision, the Labor Commissioner wrote a 12-page opinion, no less. And the Commissioner decided in favor of Ms. Berwick and ordered Uber to pay $4,152 in expenses, mileage reimbursements, toll charges, and interest. Now, Uber has appealed that decision, and once the Court of Appeal reaches the case and makes a decision, it can become a precedent in California, and potentially it's going to govern this very issue throughout the state. What are some of the potential new claims against Uber and Lyft? There could be wrongful termination if the drivers are found to be employees. There could be claims for unsafe work environments, failure to make reasonable accommodations for the drivers. ADA or Americans with Disabilities Act claims could also be brought. On the indirect liability, if the drivers are found to be employees, then the acts of the drivers under a theory of respondeat superior could impose indirect liability on Uber, Lyft, and Sidecar for the negligent acts of the drivers committed in the course and scope of their employment. There also could be indirect liability for rapes or assaults on passengers during the course of rides. Another issue on direct liability against the platform companies, such as Uber and Lyft, could be failure to make adequate background checks under the new PUC regulations. Currently, Uber, as I understand it, does conduct a background check, but they do not conduct typically face-to-face interviews, and they also do not conduct a face-to-face inspection of the driver's cars. Now, my understanding is Lyft does do a face-to-face interview, and they do look at the vehicles before they allow the driver into the platform. That could be an issue. We'll see how it develops. And one last thing that I will mention is there is a recent decision by the Labor Commissioner, or his equivalent in Florida, which came to the same conclusion. In that case, the Department of Economic Opportunity, which is similar to the Labor Commissioner in California, ruled that an Uber driver had been misclassified as an independent contractor and in fact was an employee. And presumably that driver was seeking to recover workers' compensation or employee benefits that normally would be awarded, similar to our state. So I think I'll turn over at this point to Tim and he'll talk to you about the insurance issues.
Okay. So the first thing I want to talk about is some concepts that come up in the statutes, and just by way of pointing out how quickly this is developing. Around February, there were 2 states and the District of Columbia had what they call Transportation Network Company laws or statutes. Now we're up to 23 states plus the District of Columbia, so it's, and that's just enacted laws. There's a lot more pending beyond that. So it's developing quite quickly, although there is certainly a large amount of uniformity to what you see in these laws. So the statutes have certain concepts that will help you understand how they work. One is Transportation Network Company. That's what they call Uber or Lyft or any of these companies that provide ride-sharing services through an app. Then they talk about the drivers or the participating drivers. That's also defined. Then they define Transportation Network Company or TNC insurance. Some of them refer to the riders and define them as well. Some of them talk about prearranged rides, by which and we're going to talk about the phases of the transaction in the next slide. They talk about prearranged rides, or they talk about transportation network services. So that sort of leads us into considering the phases of this transaction, because those are used in terms of the statutes, determining what insurance applies when. Those affect application of exclusions, what we call normally a livery exclusion in a personal auto policy, and they affect the way these parties are doing business and seeking to shift insurance risk back and forth. So the phases we could see here would be, first, a driver is driving around and waiting to get summoned through the app. The next phase would be the driver is summoned by the app and is proceeding to pick up the passenger, proceeding to that location. The next phase would be while the driver is carrying the passenger to wherever the passenger wants to go. And in these apps, you can either put in your destination into the app ahead of time and get a fare quote, or you can just have the driver show up and tell them where you want to go. But we have this carrying a passenger phase. And finally, there's the time when a driver is not on the app and they're just driving around on their own personal business, in which case we would expect their personal auto policy to be applying. Uber illustrates this in their blog. They divide things up into this way. Uber and Lyft have a very sophisticated understanding of how insurance is impacted by these different phases, how it affects their ability to shift risk onto personal auto policies, and their obligation to provide coverage under the statutes when they have sort of the lead in terms of providing coverage. So they divide it into the same 3 phases: waiting for a drive, having accepted a ride and going to get it, and finally picking up a passenger and carrying the passenger to the end of that trip. These phases also are sort of a logical development if you consider the way livery exclusions work. Livery exclusions normally exclude a vehicle coverage for a personal vehicle while it's being used as a public or livery conveyance. That is when you're carrying a passenger or when you're carrying property for hire. And there's 2 primary versions out there of this exclusion you find in personal auto policies. There's the traditional while being used as a public or livery conveyance. Tried and true, it's been interpreted by a lot of decisions. Then more recently in the 80s, ISO, the Insurance Services Office, tried to make the language a little bit more user-friendly, and they had an exclusion for liability arising out of the ownership or operation of a vehicle while it is being used to carry persons or property for a fee. That is a little bit more understandable, but courts found it in some certain circumstances to be confusing or ambiguous and interpreted it against the carriers. So ISO and a lot of carriers have reverted to the tried and true language. But with that exclusion, you can see there's going to be a question about are you carrying a person for hire only during that 3rd phase when you have the passenger in your car, or does it apply as well when you've been summoned through the app and you're going to get that person? And does it apply at all when you're just driving around waiting to receive a ride on your Uber app. But the typical examples for livery exclusions were taxis and limousines or carriers of property for hire. And there are some clear exceptions to that. Share the expense carpools are not governed by livery exclusions. And we have more questions arising with Uber and Lyft. You know, one is whether the livery exclusions apply to them. I think that they will generally. But these companies are branching out and doing other things. There's, for instance, these Uber Eats promotions where they'll offer to bring food to you from a certain designated restaurant. And so there's questions about what kind of, how will the livery exclusions work there as well. So let's talk about the TNC policy. These are required by a lot of these statutes now, and these were used by Uber and Lyft and these other companies even before the statutes required them. And so when we're talking about insurance coverage, we want to know first what persons are covered, and second, what autos are covered, what vehicles are covered. And so the normal business auto policy just would not work for this type of situation, or it would work, but it would result in no coverage. Because normally a business auto policy covers designated autos, whatever they're listed as. It could be all autos, it could be owned autos, it could be hired and non-owned autos, depending on the symbol used. There are numeric symbols used to describe this. But the more important issue is who is insured. So who is insured normally includes the named insured, which would be the company. It includes permissive users, but it only includes them if the named insured owns, hires, or borrows the auto. And these transportation network companies do not own the autos, they don't hire them, and they don't borrow them under the conventional interpretation of those words from the drivers. In addition to which, the policies normally will exclude the owner from whom you hire or borrow an auto, even if that would apply. So the standard business auto policy wouldn't work, and there had to be some workaround for that, and you can see that Uber posted its policy, its 2013-2014 policy, and they had some workarounds for those exact problems. First, they defined insureds to include drivers who had entered into a contract with Uber or Lyft or Sidecar and were on app at the time. And sometimes they also limited it down to situations where they're going to get a passenger or carry a passenger. And they defined autos in a similar way. They had their own special symbol or definition of a covered auto. And they said autos were passenger type autos, PPTs, while used by a named operator shown in the policy, that is to say a Lyft or Uber or Sidecar driver who has a contract with the company. And while they're logged in and into the Uber app and are en route to picking up a passenger or have a passenger that they're carrying. Okay, so that's how their carriers, the published policy from on the Uber site is from James River Insurance Company. That's how they addressed these problems. The other problem that would arise if both the driver's policy and the TNC, the Transportation Network Company's policy applied, would be that who is going to be primary and who is going to be excess, everyone's favorite insurance coverage battle. And normally, the way insurance is written and the way statutory schemes work is the policy that rates the vehicle as an owned vehicle is primary, and the policy that doesn't rate it as an owned vehicle is excess. So that would tend to make the policy on the Transportation Network Company side to be excess and the driver's policy to be primary. Of course, that would be assuming that the livery exclusion did not apply. But then midway through the term of that policy, they changed that to make sure that the TNC policy, that the Uber policy, that is to say, was primary for as against a personal auto policy, but would be excess as against a business auto policy. That is, if they had someone, a driver who had a business auto policy, that person's policy would be primary. And then there are other issues to think about. You know, is there physical damage coverage for the auto, that is to say comprehensive and collision? It didn't look like it on the policy that we saw. Is there med pay coverage? No. Is there UM and uninsured motorist and underinsured motorist coverage? No, that wasn't on the policy as well. Oops. Okay, I've gone far too far. Okay. So we have to think about all those issues in terms of what's on the Transportation Network Company's policy. And now they're required by statute to provide coverage. The most typical formulation is that they have to provide $1 million of liability coverage while the driver is going to pick up a passenger and while the driver is carrying a passenger. Some statutes don't make any requirements with regard to UM or UIM coverages or to MedPay or to PIP, personal injury protection coverage or no-fault coverage. Other statutes require those. Other statutes sort of leave it up to whatever is required by those statutes, and then you're going to have to go back and research those statutes to figure out what happens in that case. So then we need to think about what happens under the driver's policy. And the first thing to note is under a standard insurance services office personal auto policy, there are livery exclusions for the liability coverage, for the physical damage coverage, for the MedPay, the UM/UIM coverages that are going to eliminate coverage at least during the phase when the driver is going to get the passenger and carrying the passenger. So that goes back to the problem that Matt was talking about, that the drivers may not realize they don't have physical damage coverage unless they have it under the TNC's insurance policy. So that also led to something else in these statutes, which is a requirement on the TNC that it notify its drivers that it has insurance and what the terms of that insurance is, that the TNC has insurance and what the terms are and when it applies. And secondly, that they notify the drivers that their own policy may not apply and they better check with their agent about that. The other thing that happens in most of these statutes is it makes clear that the personal auto insurance company has no obligation to provide this coverage. It may do so, but that's optional. So that seems to be validating any sort of exclusion that's specific to these types of TNC type of situations. So if there's any doubt about that in the state law before then, these new statutes seem to be validating that. So we need to look at what's under the driver's policy. Other policies to consider would be passenger policies. They might be injured in an accident, and they might have a claim against the driver if the driver was negligent. They might have a claim for UM/UIM coverage in those states that require UM/UIM coverage if the other driver was at fault and the other driver was uninsured. Not every statute requires that. In California, there's a requirement that the TNC policy provide UM/UIM coverage, and it has to be in the amount of $1 million. But it only applies while the driver is carrying a passenger. It doesn't apply while the driver is going to pick up a passenger. So you got to read this very carefully. The requirements change depending on the phase and the type of coverage you're looking at. So it's important if you insure, if you have individual insureds under individual policies who are injured while they're a passenger in a Uber or Lyft or sidecar vehicle, you need to consider the impact, the interrelationship of your coverage of that passenger with the coverage that the driver has and that the TNC has. So as I indicated, we have enacted laws in various states. The first was Colorado, then California and the District of Columbia, but now we're up to 24 jurisdictions. There's other things that they require that Matt adverted to. We have the disclosure requirements about insurance. We have these insurance requirements we've been talking about. They also require background checks. Sometimes it's a criminal background check. Sometimes it's a motor vehicle record type of background check. So those types of requirements are in these laws, and they vary, again, state by state. Most states are using this formula of requiring $1 million of liability coverage while you're going to get a passenger and while you're carrying a passenger. It's kind of more mixed on whether that's required for the UM/UIM coverage, but it often is. When they're off-app in California, this law requires that there be split limits coverage. This is while you're driving around waiting for a ride to summon you. You have to have coverage of $50,000 per person, $100,000 per accident for bodily injury, and $30,000 for property damage, plus a $200,000 excess policy. That's just in that phase one while you're driving around looking for a ride. So you need to consider that as well. Every state has this, and the normal formulation is 5,130 or 5,125. Some states require an excess policy on top of that, like California, the $200,000 excess. Most of the state laws that I've read don't seem to require that. And then some states do require other coverages. Most states do not require physical damage coverage. There was a big dispute with Kansas about this. Kansas was going to require the physical damage coverage, and Uber pulled out of the state. And then it seems from press reports that they negotiated an amendment to the statute to back off that position. There's one other thing that happened is in Arizona there was a statute to invalidate livery exclusions before passenger pickup. That was vetoed by the governor. But now Arizona does have its own TNC statute. It's on that list of jurisdictions with a TNC law. So something else that is important in most of these statutes is they have cooperation schemes and notice schemes. One thing is they require either the company or the driver to notify other carriers involved and other parties involved whether the driver was on-app or off-app. Some of them require that the company provide a catalog of when the driver was on-app and off-app for the last 12 hours or the last 24 hours. So if someone's been on-app for a long, like 18 hours in the last 24 hours, that could be another liability problem for Matt Shorr to deal with. So it's important to remember that if you're a represented carrier and you're dealing with a driver who's an insured or an opposing party that has a motor vehicle claim, or a passenger, you may have some obligation or you may have some rights to get information from these transportation network companies that will help you in your investigation. And I think the last thing I would say is for the companies that are insuring the transportation network company, the other thing to look at would be excess coverage. A lot of times this is overlooked, but a lot of times excess policies will provide coverage, and then in their definition of insured, they'll cover everyone that's covered under the primary policy. So if you don't want to pick them, if you're writing that coverage and you don't want to pick up the drivers on the excess policy, you want to make sure they're excluded there. And if you're looking for more coverage, you might want to check the excess policy to see whether they managed to avoid that problem. So with that, I'm going to wrap up my remarks. We're available to take questions for about 15 minutes. And so we're going to see what questions we have. First question for Matt would be, in the litigation in Northern California, a lot of the drivers want to be considered independent contractors. Some of them want to be considered employees. Is it possible that there will be a decision where some are treated one way and others are treated the other way? Some as employees and some as independent contractors.
Well, I think the case that's pending before, well, it's on appeal with respect to, I think her name was Berwick. That case would have to go to the Court of Appeal, and a decision would have to be made to affirm the Labor Commissioner before it would apply as a precedent throughout the state. It is possible that there could still be factual issues that would preclude motions for summary judgment on the issue. The summary judgment approach to having this determined by the court without involving a jury, as both district courts in San Francisco determined was because the test for whether a person is an employee or an independent contractor is multifaceted in this state. It requires you to weigh various factual issues, and it makes it a difficult hurdle to have this type of an issue addressed on a summary judgment basis. And I think that's the reason why both judges came to the conclusion they couldn't rule on it as a matter of law, and they sent the issues to a jury for determination.
Is it correct that in both of those cases, the Uber and Lyft cases, that both sides, the drivers and the company, moved for summary judgment and the court denied both sides?
That is correct. That is correct.
And these statutory requirements that background checks of drivers be done and that motor vehicle record reports of the driver's driving history be collected, is that going to create any theory of negligence liability on the transportation network companies?
I think potentially it could, because at least that's where I think if you're representing a third party or a passenger in one of the cars, that's one of the first issues I would think that the plaintiff is going to consider, is what is the extent of the research that the platform did to allow the driver to run or drive cars for the platform. The issue that I see is that doing a criminal background check is not going to catch everyone. It's going to catch people that show up on the radar screen. And if they don't take an extra step to try to weed out people that would not pass or don't show up on the radar screen for a criminal background check, yet they may have certain issues, psychological or whatever it might be, physical, who knows, that only a face-to-face meeting could pick up. That's where I think you might get some exposure.
Okay. And here's another question. Who has to provide the transportation network company insurance? And if you read the statutes closely, every one of them says it can be provided by the transportation network company or the driver or some combination of the two. So that doesn't quite solve the problem. It leaves it for the parties to fight out who's going to pay for it. In terms of the individuals getting endorsements on their policies, that is possible. A number of carriers have come up with these endorsements. But it's important to remember that the statute requires that there be coverage and that it be in the amount of $1 million. And so I've not seen any, I've seen very few, let me put it that way. I've seen very few personal auto policies with a limit of $1 million. It's just typically not done, and so there probably have to be a combination of a primary and a personal umbrella policy to satisfy that $1 million limit.
Yeah, my thought would be possibly, and this is sort of getting in your realm, but possibly some type of a pooling agreement or a subscription agreement among the platform and the drivers to cover that. What do you think of that?
You mean like a master policy?
Yes.
That everyone can buy a certificate onto that policy? Yeah, that may be the way they go. And the fact that you could have these various options seems to indicate that these companies are going to have to come up with variable compensation systems, because if some drivers show up with insurance and some don't, their fundamental cost is different, and that might be reflected in how they reimburse the drivers. Here's another question about who has the duty to defend. That is with the transportation network company policy. Actually, here's another area where the transportation network company has to investigate. They have to, if the driver is providing the policy, the transportation network company has to verify that it's a correct policy. That means they would have to confirm with the personal auto carrier that they were providing coverage for this type of a situation. And so that could be, you know, with let's say 16,000 drivers nationwide, that could be a huge problem. It could be even more complicated than keeping track of subcontractors on a huge building, keeping track of all the additional insurance. And that does seem to put another duty on these companies, basically to do a little bit of insurance coverage investigation if they're going to be relying on the drivers to provide the coverage. And the statutes all provide that the transportation network company's own policy is primary if something goes wrong. Okay, so they have contingent primary coverage for $1 million if the driver's policy lapses or if something else like that happens, if it's canceled, if it doesn't in fact exist. Right? Okay, I think we have, let's see, I think we do have a few questions. Okay, a few more questions to look at here. Yeah, we can circulate the livery. It's on one of the slides. The livery language is, or you're saying who provides the, so the exclusions is on one of the slides. The actual, I have the actual companies that offer it. I've seen Allstate listed on there. I will, no one has sent me a copy of one yet, but I'll see if I can find one, and if so, I will send it to everyone that's on the program. I assume you mean the livery endorsement to provide coverage while they're driving as an Uber or Lyft or Sidecar driver. So I'll find that for you. There's like 5 or 6 companies that I've heard about so far that do that. Yes, from the Uber website, you can get a copy of the James River policy. This is from this is not the current policy, though. Okay, this is the policy in effect from December 21, 2013 to December 21, 2014. If anyone wants a copy, let me know and I will email that to you. Okay, I think that's all of our questions. So I want to thank you all for joining Matt and I to discuss this issue. We appreciate your attention to it. And if you have any questions, please feel free to give us a call. I have a chart with a list of all the states and the minimum insurance requirements they have. So we will circulate that to everyone that's on the list as well as soon as I clean it up. Right now it's just my notes, but I'll send a clean copy to everyone with the state-by-state insurance requirements. With that, I say thank you very much for your attention. Matt, any comments?
Thank you very much. I appreciate your time and look forward to hearing from you.